I didn't see her pants.
Could you tell if she was wearing glasses?
No.
When you saw the two girls running, could you see if both of them had the purse or one of them had your purse?
No, I didn't.
You didn't know which one had the purse?
No, I don't.
Did you ever take a good look at my client? You are under oath. You recognize that, don't you?
Yes.
Did you ever get a look at her face at any time prior to today?
Yes, I did.
When was that?
When the police officers had them in front of the police car.
At that point in time, that is when you had a chance to get a look at her face, correct?
Yes.
Thank you. Now, is it true, Mrs. Whitaker, you never were shown any mugshots with respect to any of the defendants? Is that correct?
I'm sorry?
You were never shown any pictures and asked to identify anybody who might have taken your purse. Is that correct?
I went to the police station after that.
Did they ever show you any pictures?
No.
You never went to any lineup?
No.
The first time that you got any kind of good look at the person who you have identified sitting next to me, Miss Holmes, was the same time that she was accompanied by the police. Is that correct?
Near the Pinto, yes.
Approximately how long after the incident happened was this?
Oh, I imagine about 5 minutes.
Did the police shine their lights on Miss Holmes at that time?
Yes.
Could you give me the address where it is, if you can remember, where the incident happened?
Well, it was in front of my apartment. Am I required to give my address?
Was it on the sidewalk in front of your apartment?
It was on the landing.
On the landing?
Yes.
What time was this?
Oh, somewhere before 10 o'clock.
How far is your apartment from the nearest street light?
Oh, I'd say about directly across the street.
So the whole width of the street plus the width of the curb to the landing. Is that correct?
Well, it was a little bit dark where the landing was.
Can you tell me what the person that you have identified today as Miss Holmes was wearing on that evening?
Beg your pardon?
What was the person wearing who you have identified today as Miss Holmes? What was she wearing at the time this happened?
She was wearing some sort of a stocking cap. I remember that, and some little sleeveless t-shirt.
Do you remember the colors?
No.
Do you remember shoes?
No.
Did you tell the police any style of hair? Do you recall?
Well, her hair was covered with the stocking cap.
I have nothing further.
Anything further from the people?
Nothing further, Your Honor.
You may step down, madam.
Call Officer Wake.
You are excused at this time if you wish to go.
Thank you.
You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Peter Wake, W-A-A-C-K.
What is your occupation and assignment?
I am a police officer for the City of Los Angeles, assigned to Venice Division Patrol.
Were you so employed and so assigned on November 5, 1996 at approximately 10 p.m.?
Yes, I was.
On that date, did you take a report from the previous witness concerning a theft of her purse that occurred in the 1700 block of Penmar Avenue in Venice?
Yes, I did.
After you took that report, what did you do next?
I placed the victim, Mrs. Whitaker, in my police vehicle.
Where did you go next?
I went to the area where the victim stated that she had last seen the suspects running.
All right, I am defense attorney. My name is that a Mrs.? Ms. Warden.
Yes.
W-O-R-D-E-N.
I am the court.
I am the witness.
I am plaintiff attorney Mr. Day, and this begins with me. Ready?
Mm-hmm.
Sir, what is your present occupation?
I'm detective at County Sheriff's Department.
And how long have you been so employed?
About 4 years.
And on the morning of May 8, 2001, did you come in contact with or have contact personally with the defendant in this case, Mr. Dan Blake, at the County Medical Center?
I did.
And at that time, were you with Mr. Blake in the emergency room of the County Medical Center?
Yes.
Did you take a statement from Mr. Blake?
I did.
And prior to taking the statement from Mr. Blake, did you advise him of his rights pursuant to the Miranda decision?
I did.
And how was that done?
I verbally advised him of his rights while reading from a standardized department Miranda waiver form.
And by any chance, do you have a copy of that form with you?
I certainly do.
And would you show us your copy of the form?
Okay, definitely.
Your Honor, could we mark this? I am not certain if the court clerk is unavailable. Perhaps we could mark it later at the finish of the morning session.
She is coming. It will be marked as People's number 1.
This would be 2. Medical records were number 1.
Okay, People's number 2 and motion number 10.
Did you read that form in its entirety with regard to the rights and advisement to Mr. Blake?
Certainly.
And when you did that, did Mr. Blake appear from his actions and demeanor to understand what you were saying?
Yes.
And after advising him of his rights by reading it from that form, did you ask Mr. Blake whether or not he would willingly waive his rights?
Yes.
And did he respond?
Affirmative.
And did he indicate to you that he would waive his rights?
Definitely.
Okay, did Mr. Blake in fact sign or mark on that form to indicate that he understood he was waiving his rights?
Definitely.
When Mr. Blake was signing that form, did he write his signature with his left or right hand? Do you remember?
I believe with his left hand.
In fact, his right arm was injured, was it not?
Objection, leading.
Sustained.
Okay, my question to you is, did Mr. Blake have any injuries to either arm as far as you were aware of from your observation?
Yes.
Do you recall which arm?
Absolutely. The right arm.
Did you ask him whether or not he would sign the form?
Certainly.
And do you recall specifically what he responded as far as whether he would sign the form?
I do not remember specifically what he said, but he said he would have to do it with his left hand because he was right-handed.
Okay, then he did actually sign the form.
Yes.
Did Mr. Blake indicate to you in any fashion while you were instructing him regarding his Miranda rights that he felt that you were threatening him?
No.
Did he indicate to you in any fashion that he felt anyone was threatening him?
Never.
When you spoke with Mr. Blake and were giving him his Miranda rights, were you armed with a weapon?
No.
Did Mr. Blake seem to understand his Miranda rights as you read them to him?
Correct.
I will object to that, Your Honor. Appear to understand the Miranda rights. To me, we are talking about a mental state, and under the circumstances of the case where the man had been shot and given morphine, I do not think that there is a reasonable inference to be drawn as to what his mental state was from his physical appearance. And even if there was such a relationship, I would think that there is not a foundation that this officer is qualified to give that kind of an opinion.
Your Honor, if I may, what I am asking is for his observation of the defendant's physical appearance or things said by him that would cause this officer to think that Mr. Blake, in this officer's view, did not understand. I would submit it.
That is not what you asked. Sustain the objection. You may ask that next question.
So, was there anything in the defendant's appearance that caused you to think that he did not understand his Miranda rights?
No.
Did Mr. Blake, after he signed the Miranda rights form, do anything that caused you to think that he did not wish to go on talking to you?
No.
At some point, did you ask the defendant questions?
Yes.
Did the defendant at any time when you asked him questions appear to you not to understand the questions?
No. Not until the latter portion of the interview.
Okay, how long did the interview last?
Around an hour and a half.
And by the latter portion of the interview, are you speaking about just the last few minutes of the interview?
Yes. The last.
I am going to object as leading. Move to strike the answer.
Sustained.
What portion of the interview are we talking about? How much time?
Perhaps the last 20 minutes or so.
And what was different about the last 20 minutes of the interview that you are referring to at this time?
He was not as responsive to the questions. Sometimes it was necessary to ask the question twice.
When you say not responsive, what do you mean by that?
When I first interviewed him, his answers were much more detailed and pertinent to the question, but later on, towards the last part of it, he was beginning to nod or indicate that the medication was starting to have some effect on him.
Did he, during that last part of the conversation, seem not to be, what, as rapid in response to you? Would that be accurate?
Yes.
Objection, leading. Move to strike.
Sustained. Rephrase your question, please.
What do you mean by not as responsive to the questions?
He was answering the questions, but he would simply delay his answer for a period of time. I wondered whether he was thinking about his answer or if he was simply ignoring me or whatever. As I stated before, I was not sure what was going on in his mind at that point.
Move to strike the last portion of the answer as non-responsive.
Which portion?
Sustained.
The last, I was not sure what was going on in his mind?
And the purpose of the delay. He said he delayed his answer, and everything after that was non-responsive.
The objection is overruled. It is explanatory.
In those last few minutes or so, despite the delay in his answers, did Mr. Blake's answers in fact seem to be appropriate to the questions?
Yes.
Was there anything in that last 20 minutes or so that caused you to feel that he did not wish to keep talking?
No,
Now, during the course of your interview, from time to time, did the defendant indicate to you that he was in pain?
yes,
Was there anything that you were doing that appeared to cause a painful response from the defendant?
I am going to object to that. Calls for speculation as to whether the officer caused the defendant to have pain.
Well, he said caused a painful response.
I can rephrase the question. It was not a good one.
Please.
Did you ever physically handle the defendant in the course of the interview? In other words, put your hands on him and move him around in some fashion?
never. I did pull the covers up around him on one occasion.
Why did you do that?
I believe it was at his request.
Other than that, did you ever physically touch the defendant during that interview?
No, sir.
I think that is all for now.
Have you completed your direct examination then, Mr. Day?
Yes, I have.
Okay, you may cross-examine.
Thank you, Your Honor. Officer Kelly, I believe you stated you were unarmed on the day you took the statement from Mr. Blake.
I believe so, yes.
Is it your habit and custom to carry your weapon with you?
Not always. Just as today, I am not armed either.
When do you carry it and when do you not carry it?
Usually when I am out in the field conducting an investigation, making contact with residents and that type of stuff.
Exactly where were you before you interviewed Mr. Blake on May 8th?
At the West Lake Clubhouse.
Okay. You were there involved in at least observing the arrest of Mr. Blake?
I was standing in the street outside, in front of the clubhouse, that's correct.
When you first arrived at the clubhouse, were you aware that the officers believed the homicide suspect was inside?
Yes.
And where had you come from, home or from work?
Your Honor, excuse me, I object. What is the relevance of this with regard to the subject of this motion?
Overruled. I think I know where she is going. Go ahead.
I believe I was somewhere downtown near a motel.
Interviewing suspects or a witness?
I believe I had attempted to contact the manager of a motel.
A witness in a case, is that correct?
Yes, in this case.
Now, at the time you first saw Mr. Blake in the emergency room at the hospital, is it your testimony there were no other officers present?
There were none other than Officer Smith, who was in plain clothes too.
So Mr. Blake was left alone in the emergency room with no officers until you got there, is that correct?
Yes?
Now, officer, you stated you were at the park where Mr. Blake was arrested.
Yes, ma'am?
And did you see Mr. Blake removed from a library building?
I saw him being escorted to the ambulance. That is the first time I saw him was on the sidewalk outside the building.
And two officers were helping Mr. Blake into the ambulance?
Yes, I think so.
And at the time you saw Mr. Blake there, did he complain about physical pain?
I remember him complaining once he was in the ambulance. I do not remember hearing him specifically right outside the door.
Now, did you ride in the ambulance to the hospital with Mr. Blake?
Yes, in front.
Did you observe injuries to Mr. Blake while you were in the ambulance with him?
Yes.
And what did you see?
I saw a wound to the area of the right elbow and an additional wound to the area of the right front thigh.
And would you describe the injury to the elbow?
Objection, Your Honor. The witness was riding in the front and has never claimed to be close enough to see the injuries clearly. Besides, he...
Overruled. The question merely asks him to state how the wounds appear to him despite his closeness to the victim. You may continue, Officer Kelly.
It was a through-and-through wound, I believe. I was not certain of the entry and exit point at that location at that time because Mr. Blake was being treated by ambulance personnel, so I never got a really close look at either injury at that time.
Could you also describe the injury to the leg?
There appeared to be a gaping type wound to the upper thigh. I would estimate 6 or 7 inches in length with additional small bruises to the area of the right hip.
While you were in the ambulance with Mr. Blake, did you question him in any way?
Never.
And did Mr. Blake make a statement to you while you were riding in the ambulance to the effect that he could not understand why he had been shot?
I do not remember him saying that to me personally in the ambulance. He may have been talking to the ambulance person who was leaning over him and attending him. He did comment about something like that to me. However, at the time, we arrived at the hospital.
What was the comment he made to you regarding why he heard, or regarding not understanding why he had been shot?
I believe he simply asked, "Why did they shoot me?"
Number 2. Okay, I am defense attorney, Mr. Doyle, D-O-Y-L-E.
I am the court.
I am the witness.
I am defense attorney, Mr. Patterson.
And can you guys hear us okay in the back?
Yes.
Okay. All right, so starts with me, cross-examination, ready? You testified that the White Hawk was destroyed,
That's correct.
and you testified that that was by your orders,
That's correct.
and you testified that at some time or another you saw it being destroyed or certain parts of it being destroyed.
That's correct.
Also, you saw the results of its destruction, correct?
Correct.
Now, what code section authorizes you on a lien to destroy somebody else's property?
Well, let me ask you a couple questions. Why was this boat destroyed?
Nobody did on the boat or purchased the boat at the public auction.
So when that was through, lien procedures were finished, is that right?
That's right, and the title reverted to the Port District.
Title reverted to the Port District?
That's correct.
Is that under a code section?
Not that I know of.
Well, under what section, to your knowledge, do you have the authority to do that?
Who told you that the title reverted to the Port Authority?
Well, that particular question came from our attorney, Lyndall Van Dam.
And did you talk to him prior to the time that you destroyed the White Hawk?
Yes, I did.
And what date was it that you talked to him about destroying the White Hawk?
It would have been sometime in September of 1980.
Why was it destroyed? Did you want it destroyed?
Well, we had nothing else to do with the boat.
You tried to sell it and couldn't sell it?
Yes, we tried to sell it and it didn't sell.
How long had it been sitting there after the sale before you destroyed it?
Over a month, about 6 weeks, I believe. I had even phoned the Coast Guard about the documentation.
Hearsay, just a minute.
Counsel,
We're asking him about the basis for the destruction of the boat.
He can testify he called it the Coast Guard, but not the conversation.
Okay.
I would say that he can because it forms the basis of his opinion. It's not being offered for the truth of the matter asserted.
The objection of Mr. Doyle is sustained. Go ahead, counsel.
Now, you talked to the Port District's attorney in September.
Yes, I did.
Was that influenced in any way by the fact that I was substituted on this case in September 1980?
No.
Where were you keeping this boat after the lien sale, which did not result in a sale?
It remained tied where it was all along.
This was not available for rental, I take it?
That's correct.
You didn't haul it out of the water?
Well, we hauled it out of the water when we destroyed it.
Okay, go ahead, Mr. Doyle.
Sir, did you at any time ever take up with the Port District or the Police Department or the District Attorney's Office the fact that there was no lien on this vessel on December 6, 1979?
Yes, I did.
Did you? With whom?
Officer Lovendahl, I think was his name.
And what prompted you to discuss with him the fact that there was no lien on this vessel?
If I recall, he called me to discuss the nature of the charges, and he asked me specifically whether we had a lien against the boat, and I answered no, we didn't. I explained to him about the boat being in our care and custody and all those things, and that we were going to file a lien the next day.
And during all this time that you knew about the holding by the magistrate upon Mr. Jacobs destroying...
Objection. There's been no show of proof that he knows anything that the magistrate held.
Objection is sustained.
Do you recall my question as to whether or not you testified on February 6, 1980?
I testified then.
And do you recall testifying you heard the subject of a lien come up in court?
Yes.
And did you further testify a little while ago that you were aware of the fact that there was a discussion between the court, the district attorney, and the public defender that the alleged event of December 6, 1980 had destroyed the lien of the Port District?
No, I don't think you ever asked me that.
Well, I asked you the question. Do you recall it?
Well, it was objected to or something, and I never answered it.
Well, let's put it this way. Once again, with the court's permission, you were in court on February 6, 1980.
Correct.
You testified in court on that date on the Jacobs matter.
Why don't we get right down to the nitty-gritty? Why don't you just spell it out? What you want him to acknowledge. Just say, isn't it a fact that you were in court on the date of the preliminary examination and that the judge in open court said whatever you want?
I'm going to object to that form of question. Also, there's been no show that he was in court when the judge ruled on anything.
Let's ask him. Were you in court when the judge made his rulings?
No, I wasn't.
Where were you? Out in the hallway?
Or at home. I think it went on for a period of time, didn't it? I'm sure I left before the hearing was over.
Fine. Now, if you say that you were not in court at the time that that event occurred, did you subsequently learn from the police department or the District Attorney's Office the fact that the judge held Mr. Jacobs upon the proposition that the 4th District's lien was destroyed by fire?
No, I didn't.
You knew that, didn't you?
No, I didn't.
Nobody ever told you that?
No.
This is the first time you heard that?
Yes.
Objection asked and answered and argumentative.
Objection is overruled. He's answered the question. So there is no confusion, ladies and gentlemen. There has not been a prior trial in the case. Let me explain what happens to you when a felony is filed. A complaint is filed in municipal court, and any person charged with a felony has a right to a preliminary examination in a very short period of time to determine whether or not there is sufficient grounds to go to trial. The judge doesn't make a determination of guilt or innocence. The judge simply makes a determination whether there is sufficient evidence to justify a trial in the matter. The standard is, would a reasonable person have a suspicion? It's much different than the standard of proof at trial. It's not nearly as strong. So you have an initial determination as to whether or not there's justification to proceed. But that is in no way a trial on the charge, and there is no indication that the judge found him guilty beyond a reasonable doubt because no such finding was made. Go ahead.
Thank you. I want to get something clear. Do I understand correctly from you that this is the first time you heard the fact that the judge held that your lien had been destroyed in the fire of December 6, 1979?
That's correct.
Nobody ever discussed that with you before?
That's correct.
And if somebody had discussed that with you before, and you knew that there was no lien recorded, would you have gone to somebody and said, we didn't have a lien, and therefore we didn't lose anything?
I would have brought it to their attention that there was no lien officially filed. To say we didn't lose anything is inaccurate, though.
I beg your pardon?
To say that we didn't lose anything by this event is inaccurate.
Let me ask a couple questions. I'm a little bit vague on the procedures. You say you did something at the end of November, but you did not file a lien. What is it that you did at the end of November?
We sent a registered letter to Mr. Jacobs telling him what fees were owing and advising him that in 10 days from the date of that letter that we would file a lien if he didn't reconcile the fees.
Was there anything posted at the end of November?
His boat was posted and impounded by the Port District.
And what does that mean? Let's say you have my boat there and you posted it. If I came to use my boat, what would happen?
You cannot. If you look at the seizure notice that Mr. Patterson has a copy of, it stipulates that you cannot go aboard the vessel or move it or do anything with the boat.
So you had posted it so that the owner could not enter onto the vessel in any way, is that right?
That's correct.
And you do that before you file a lien?
That's correct.
Okay, go ahead, Mr. Doyle.
Which of the two gentlemen in the law firm that you mentioned gave you the advice to destroy the White Hawk? Which of the two members?
I only recall mentioning one person, and that's Lyndall Van Dam.
Do you make a distinction between a notice of intent to do something and the actual doing of something?
Sure do.
Thank you. No further questions.
You need 10 days' notice to file the lien, correct?
We do.
And you would have to post it on the 27th to have notice on December 7th, 10 days?
Right.
Okay.
Make a motion, the last question and answer be stricken. Any notice of intention is not governing the situation. The sole question is whether or not on December the 6th, 1979, there was in fact a lien.
Motion is denied.
Thank you. Have this marked next in order.
It may be marked next in order. People's number 46 for identification.
Between the fire on December 6th and the time that you sold the boat, which you said was September, a period of 10 months, did anybody pay any fees for the storage of that boat?
No.
All right, and was it kept in a slip at the end of the dock where it's in the pictures?
Yes, it was.
And is that a slip you normally rent out to people?
Yes, it was.
And how much do you normally take in as a fee for the rental of that one slip per day?
Well, to replace it with a paying boat the same size, it would range from $5 to $6 a night, depending upon time of year.
Every night for a period of 10 months, you collected nothing?
That's correct.
Were you present at the auction of that boat, the sale of that boat?
Yes, I was.
How many prospective buyers or other people were present at that time?
Not a single person showed up.
Was it advertised?
Yes, it was.
You have participated in previous sales?
Yes, I have.
Have you ever had a case before where nobody showed up? Is that something that commonly happens?
No.
Have you ever had a case like that before?
There was one time when someone showed up an hour late and I just reheld the auction for his benefit, but someone has always showed up and bought the boats.
Where do you publish this notice? How do people find out about it?
It's in the legal ads section of the newspaper, and we also post the boat and post the gate.
Okay, in response to council's question, you said there were other things that led you to believe that he might